IMTV International Broadcast Media. This is the Lawyers Den, a special report from American politics on the Supreme Court. This unique broadcast brings you in-depth discussions with American leaders in the law to discuss the current Supreme Court nominee, Judge Amy Barrett. I'm Bill Tresvant, and along with my esteemed co-host, Nick Palavita, we will be bringing you the Lawyers Den. Nick, please.
Yeah. What am I supposed to do now, Bill?
Well, we have quite the lineup, and I would think.
Oh, okay. I'm going to introduce them. Let's go to Middageville, Georgia, and meet with our professor, Adam Lampanero from Georgia. Welcome to the show.
All right,
great to be
He is
here.
a constitutional law scholar and a professor, a JDLLM. He finally put that on there. Not that we want to make you LM envious, but it is what it is. And then we also have from Salt Lake City, Bill. We actually have Jeff Teichert, who's also a JDLLM. Okay. And also coming in, well, I know she was heading to Washington, D.C., but she's not there anymore. Gayatri, welcome to the show. And Gayatri is also a JDLLM, but I'll have her put that on her bio next time she's on the Lawyers Den. But Gayatri, give us a little introduction about yourself. The other people that are in the den are like lions. They've been nice to each other for quite some time. Tell us a little bit about where you're from, what you do, et cetera, et cetera.
Well, good evening. It's a pleasure to be here in such a company. I'm an attorney. I practice law. I started practicing law in Colorado. Then I moved to Washington, D.C. And currently I am in Florida, Miami, focusing on immigration law. My LLM is in international business investment. So I do a lot of investment visas. And I also have been involved with issues that surround the immigration issues, particularly when it comes to southern border with United States and Mexico.
Yeah, but now you're originally from Lithuania, right?
Yes, Nick, very good memory.
Yes, of course, right. Lithuania, and then you came and you went to University of Denver, correct? Right. Is that where you received your LLM, was at University of Denver?
I did, and then I had a big arbitration international lawsuit against Republic of Moldova in Vienna. We won it, and then I went to DC, and then the life just happens.
Okay. Are you practicing law in Florida right now then?
I am.
Oh, okay. All right. So she got a member of the Florida Bar Association. That's a good thing. Yeah. Judge Moore is supposed to join us. He's not here yet. I will let you know when he does appear. He's actually the president-elect of the National Bar Association, but sometimes he may be stuck in traffic. I think he lives in Florida, but I'm not sure. He may live in Mississippi. I don't know. But you're definitely in Florida, definitely in Miami, and of course the other school I went to was the U, baby. The U. So I went to the U and Denver. So Adam, I know people have heard you before, but the thing is, as Lawyers Den expands into other countries, tell us a little bit about your background, who you are, where you're from, and what you do.
Sure. I'm an attorney, and I did my undergraduate at the University of Southern California. I received my law degree from Ohio State University and an LLM from NYU. I was a commercial litigator for about 5 years before entering academia, and I've taught for approximately 10 years at various law schools, and currently teaching at Georgia College and State University in Milledgeville, Georgia, and loving it. I also do appellate work, and I've been involved in I've written about 10 or 11 amicus curiae briefs in Supreme Court cases over the last 5 years, and have a great interest in constitutional law and Supreme Court jurisprudence.
Yeah, and you're based in Georgia, right?
Milledgeville, Georgia. That's correct.
Right. Okay, Jeff Teichert, tell us a little bit about yourself, who you are, where you're from, what you do.
Well, Jeff Teichert, I'm from originally from here in Utah, where I live now, and I have a JD from Brigham Young University and LLM from George Washington University Law School. My emphasis was English and early American legal history because, I wanted to make a lot of money or something.
I'll get you right to the top, but go on.
I have a passion for constitutional law too. ran for the Court of Appeals in the state of Washington in 2006, but didn't quite get there. And I also enjoy doing appellate work, like Adam talked about, because I guess I enjoy the legal writing and the applying the broad concepts that we find in constitutional cases. I've had 3 amicus curiae briefs in the U.S. Supreme Court, so not quite as many as him.
No, and our host today, of course, is Bill Trezevant, who heads up American Politics. He's an attorney out of Washington, D.C., the Tower of Power. So he's the one who's actually going to be asking the questions. I'm just going to be causing trouble until somebody stops me, as Jim Carrey would say. Somebody stop me. And so Bill, go ahead and give it a start. What are we doing today?
Okay, well, what we're doing today is today was the last of the hearings. I'm going to bring everybody up to speed, and that is to say that what we should know is that procedurally, the Senate has scheduled a vote. Well, actually, the Judiciary Committee is scheduled a vote to recommend Judge Barrett to the full Senate for confirmation, and that vote is scheduled for next week. So we've had this week of hearings, Monday, Tuesday, Wednesday, and then today were the character witnesses. And as we always do here, we want to focus in on our esteemed guests. And so with that, I'd like to go around the panel. And let us start this evening with a fan favorite, and that would be Adam. What did you learn today? What did you know? Did you see anything that might derail this nomination?
No, I really didn't. What I saw was that she is just really a fantastic nominee. She's brilliant. She conducted herself extremely well. She has the utmost integrity. Her former students and colleagues speak incredibly highly of her. And most importantly, she comes across as a woman of great, not only integrity, but a kind and compassionate person. And most importantly, she's an originalist. And I think another originalist on the court is a good thing for the Constitution and a good thing for democracy. So I think she gets narrowly confirmed. And I think the Supreme Court will have one more originalist joining the bench.
Fantastic. I'm just going to make quickly as we go around. We have one originalist in the House. Jeff, what did you learn? What do you know? What did you think about today?
Well, I would echo everything that Adam said. I think this is a fantastic nominee, very attractive, very intelligent, very well qualified in terms of experience and background. I also love the fact that she's an originalist. That may not be true of everyone, but I think she'll get narrowly confirmed, largely on a party line vote. What I saw today mostly was different interest groups coming, bringing witnesses in and talking about what they either liked or didn't like about this nominee. And it was mostly based on forecasting what she would do on the bench, which we've talked about on this show before is kind of hazardous business, trying to read the tea leaves. We saw David Souter, who was appointed by the first President Bush, who was probably, at least by the time he left office, the most liberal judge on the court. We saw Harry Blackmun, who was appointed by President Nixon, write Roe versus Wade. I mean, you could go down a list of justices that haven't turned out the way people thought they were going to. I know Adam predicts that this particular nominee is going to be the next Justice John Paul Stevens. I don't know that I agree with that prediction, but I can't say it isn't true either, because presidents have tried to crack that code, and unless you go about asking them how they're going to rule and only nominating someone who will tell you, you're not going to know for sure. And if you nominate someone who tells you, they've got to tell everybody else too. So anyway, that's what I saw today. Some of her law students and law clerks spoke as well, spoke very highly of Judge Barrett, as you would expect.
Mm-hmm. Okay. Okay, fantastic. And just for our audience, we're keeping record. We now have two originalists, so of course they're happy. And Jeff is an originalist, as is Adam. So we want to make sure that we're not stacking the deck here. And that leads us to you, young lady. So what did you know, and what did you learn, and what do you
Well,
think?
just to keep the record straight, I'm not an originalist,
Okay.
but I wanted to say, as much as I like to bring a new color into the conversation, at this point, I have to agree with the previous speakers. The nomination, the proposed judge appeared very composed, very knowledgeable when it comes to different cases and her rulings thereof. However, and I also wanted to compare her to another nominee that we not long time ago had an opportunity to observe in similar grilling and similar questioning, and in comparison she appeared very well composed, very strong, very calm, and that gives me hope when it comes to her decisions in different legal matters, and it also impressed me significantly.
Okay, Nick,
I'm here.
well, I know because I rely on you.
Oh, then you're in deep trouble. But go on, counselor.
No, your thoughts, Nick, please.
Oh, a couple things. Number one, I found Guidry quickly was able to put JDLM behind her name during the break. I don't know how she did it, but it was like poof, like magic. Number two, she actually has Botticelli's Birth of Venus, at least part of it, behind her, which I think is quite interesting. From the Uffizi, it's actually from the Uffizi, the Uffizi Museum in Florence, Italy, for what that's worth, right? So I'm scoring points for the European Masters. And my thoughts, of course, the number one graduate from Notre Dame University School of Law deserves to be on the bench. Sits on the Seventh Circuit, nothing bad behind her record, highly qualified, and she will sit on the bench. So that's really what's going to happen. My real question is, are we going to expand the bench, which they did not only in the year 1807, but also did in 1837 and 1862. So we had 3 expansions of the bench, and I wouldn't call it court packing. I would call it the court equity, the Merrick Garland Court Equity Act of 2021. Is that going to take place? So that's my off-the-cuff opinion, for what it's worth, Bill.
Okay. Well, first, I do want to say that, well, the two originalists are at least matched because I am siding with our new guest, Nick. I guess that would make you the swing vote, or at least the Chief Justice of this panel.
The Roberts of this panel?
That's right.
He had such power. I like Justice Roberts. He's
okay, and that would make me the poor people's lawyer, since I do not have an LLM. So
sure.
Thank you for allowing me into your August group. Now, for our panels, I want to begin with just this basic observation, and that is this: that it is quite stunning, and this is to pick up on your comment, G, that it is quite stunning that this nominee, that nobody spoke ill of her. I mean, first of all, generally, Shakespeare hated all lawyers. That's why Nick doesn't read Shakespeare.
I don't. All those books back there, no Shakespeare.
No Shakespeare.
I burned his books years ago, but go on.
Okay, all right. And second, though, that everybody has their favorite "I hate my lawyer" joke, and I have a lawyer joke that I don't like. But it's stunning, and you're quite correct that everybody speaks highly of her, and even the people that may disagree with her in terms of her judicial philosophy. What do you guys make of that, G?
Well,
yeah. What do you think of that?
Well, it's, for me,
Mm-hmm.
It's a little bit troubling. Ideally, in ideal world, there would be a candidate who would be a little bit more liberal, a little bit more open to certain issues. However, as it was mentioned before, I really don't want to assume of her future decisions based on her certain expressions, because as we know, law is very fluid and law has so many factors and different components, and it's very case specific. And I think Judge Kavanaugh also surprised us with a few decisions. Therefore, I still put it in kind of a basket, and I'm still pretty hopeful with when it comes to this Supreme Court combination.
Okay. Okay. All right. Well, I appreciate that. But I can't help but continue to uh, argue with my colleagues, and that is to say that the just as there are many stories where justices quote unquote surprise us and find the weight and the responsibility of the robe to suddenly enlighten them. We have many more examples where the justices are appointed and they are as billed and they don't change. And we can go either way, but first let's just begin with, assuming she doesn't change, what kind of court are we looking at then, Guy?
For me, that creates a little fear, and it for me, it's not a perfect court. It definitely creates some trouble when anticipated to certain landmark decisions. I am very involved with when it comes to different human rights, and again, as I mentioned, I'm not an originalist. I do not believe that Constitution was meant to stay as it was written in 18th century. However, in this situation, with her ability and her credentials, it seems that that's what we have and that's what we need to go with. And I'm hopeful that it's difficult for me, to be honest. I have to definitely admit that she's incredibly conservative, and that definitely gives me a little worry. But at this point, there is nothing I can do. At this point, as Nick mentioned before, she is there. She will be elected, and we have to just come into agreement with it and see what happens next.
That leads me to this question, and Nick is going to love it since he already proposed it. And it goes to our colleague on the other side of the aisle. Should there or should there not be a Merrick Garland equity reform of the Supreme Court? Jeff.
Okay, first of all, Bill, I think it was very unfair for you to talk about lawyers that way. Why judge an entire profession by 600,000 or 700,000 bad apples?
Thank you, Jeff.
Thank you, Jeff, for sticking up for the profession. Thank you, Jeff.
I personally hope that they don't try to pack the court. I understand maybe there will be people that take exception to that terminology, but I hope they don't add justices. The number 9 has been stable for a long time, and I think it's big enough to permit a wide variety of views without having it be so big that no one voice really matters. So and then I'm a little bit of a traditionalist when it comes to that sort of thing.
Mm-hmm.
I think what it will give you, it's really hard to say what this particular justice will do as far as outcomes. I think in terms of methodology, it will be a more originalist court to replace Justice Ginsburg with this particular justice. And really, things have been headed that direction for quite a while. I think I've mentioned on a previous episode of this program, I did a amicus curiae brief in the Heller case, which was about the right to keep and bear arms, whether or not it's an individual right. The side that I wrote for happened to get the majority opinion, which is a very originalist opinion by Justice Scalia. But interestingly, the dissents in that case were also written with a very originalist methodology. And it was really a debate over what the original intent was at the end of the day, because both sides of the argument premised their arguments on originalist methodology and ideas. So I think you're going to see a court where even the more liberal justices are going to make an appeal to originalism in hopes of persuading their colleagues to follow their positions.
Okay, Adam, that brings me to you, and my question to you is a little narrower. because even though you're an originalist, and I can forgive original sin, but don't mind me. But over the last couple of days, you have really been trying to carve out almost a moderate position under the umbrella of the originalist kind of school of thought. Now, wouldn't you be amenable to a Merrick Garland equity plan if it provided for, on the one hand, more originalists, and on the other hand, those that might be more akin and aligned with the moderate center of your school of thought?
No, I wouldn't agree with that, because I think it would even further politicize the court, and I think it would also damage the court's institutional legitimacy. But I do have an alternative proposal that I think should be considered.
Okay.
I think that if you want to
I have to ask, Justice Palavita, will you, or Legislator Palavita, will you accept a friendly amendment from Professor Lampanelli?
I didn't hear the amendment because the thing is, what happened, there was some static, so if he can repeat.
Well, he's about to propose an amendment, so will you yield the floor for the purposes of him presenting it?
Of course, I'll yield the floor to listen to a friendly amendment, but if he has another type of amendment, I know what to do. But go on.
I think it's friendly, although it might be considered radical. I think that the law should be changed to require that for any Supreme Court decision to have for reversal or affirmance of a lower court should have a 6-vote supermajority. Wow. And we should get rid of 5-4 decisions. They are exactly what is causing damage to the court's institutional legitimacy, the perception that decisions are undemocratic, and it would promote consensus, it would promote incrementalism in the law, and it would promote moderation. So that's my proposal.
Radical.
Nick.
Yeah.
It's a serious proposal.
Yeah, it's a serious proposal, and it doesn't seem like it's a bad one either. I mean, certainly, it's something that I've never seen advanced out there, but it's certainly a possibility. Again, it would have to be, I guess, passed by both houses of Congress and also signed by the presidency. Be an interesting one to put up in front of debate. I've never heard that one, Adam. That's brilliant of you. It's innovative of you.
Thank you.
Certainly not like what I would expect from somebody in the middle of Georgia, but it was certainly brilliant, innovative. I guess that though you spread your wings, that you went to New York University and also Southern California. Now, looking at Amy Coney Barrett, just as a side, if there's anything against her, is the fact that she doesn't have a lot of worldwide experience like we do on IBM TV, as people watch us from all over the world, such as Okonowaku Umera from Nigeria and other people, where Guidry, on the other hand, is an internationalist. She's been all over the world, so she's seen the world. And one problem that we have with American jurisprudence and Americans in general is they're my foreign friends, narrow-minded American. They don't see things outside of the United States system. So Guidry, when you were overseas in Lithuania, were you able to experience a judicial system that was different than the United States, Guidry?
Oh, that's a tough question. It carries a lot of weight, I think. Yes and no. I think law in general, when it comes to the constitutional law, is pretty static. It carries a lot of weight. It carries a lot of history. It carries also a lot of culture. There are changes, there is movement, but it's not as I would prefer, I would like. Therefore, I think it's similar everywhere. When it comes to Professor Adams' suggestion to change the Supreme Court's kind of like voting requirement 6-3, I'm very curious. Wouldn't that delay the process itself? How possible it is? It seems it's even now like 5-4. Sometimes it's a pushy way. So just
Adam.
Well, the purpose, in my view, would be to avoid decisions that are very divisive, particularly on political and social issues. That the 6-vote requirement would really require the court to arrive at a consensus. And it would lead, in my opinion, to decisions that are much more moderate and much more incremental. And I think that that's important to maintain the court's legitimacy. And I think it would again, it would avoid those 5-4 decisions that when they're based on ambiguous provisions in the constitutions engender a lot of criticism. And I think that that's a bad thing for democracy, for the court's legitimacy, and ultimately for the people.
Well, I guess, Jeff, how do you feel about Adams' friendly amendment to Nick, a super majority vote?
His radical proposal, Jeff.
Well, I admit I have not thought about it before, but my initial reaction is it's a very interesting idea, but I don't think I would be for it for a couple of reasons. One, I think it would tend to leave splits in the circuit. It wouldn't resolve. There would be a lot of issues of law that come up to the Supreme Court that would be unsettled, that would remain unsettled for a long period of time because there wouldn't be a precedent of the Supreme Court resolving it. So that's my initial reaction. I don't think it would foster stability in the law, but it's something I'd have to do some more thinking and research on to decide to have a really developed view on it. But that's my gut reaction.
Oh, I have another idea, Adam. What we should do is give Congress the ability to do a study on it, which means it'll never get resolved.
Oh, Nick.
Well, I have one more idea too, if you want me to.
Okay. Yeah, no, I want to hear it. This is good. We have innovation from Georgia. This is very interesting.
I have been wanting to know for years why the Supreme Court has never relied on the Ninth Amendment to create unenumerated constitutional rights and instead created a doctrine called substantive due process that makes no sense, has no legitimacy. I'm curious as to what you guys think of that.
Okay, well, frankly, being the illegitimate child of legal education here, I'm not sure that I'm even in a position to react. Gayatri?
Well, there are a lot of issues that at this point I'm thinking when it comes to Supreme Court. In addition to Adams, instead of answering the question, something that I was also thinking about it, what if we put limit on the terms that the judges have at the Supreme Court? If we're going out there, why not to give ourselves a little bit more options and to see where it could take us if we're expanding, the structure of it itself.
Okay, but Nick, wouldn't that just inject us an amount of a degree of uncertainty into the court rather than stability and allegiance or respect for the institution that Adam and Jeff so dearly guard?
The thing is, I find that to be interesting, but also Gayatry's idea of having term limits on judges, that may not be a bad idea, because the thing is, let's get real. Seriously, somebody can sit on the court till they're 105. If they live long enough. Is that really what you want on the court? And you don't have enough young people coming on board. I mean, one good thing about Amy Coney Barrett is she was a young person coming on board, which helps the court. I totally agree. But should Ginsburg been on the court for so long in their 80s? And frankly, here's another problem I have with people serving so long. Bill, it doesn't give young people an opportunity to move up. It's like being a professor of law. Not that I'm beating up you, Adam, but there's a lot of law professors, they sit on their positions forever because they can. So a young, brilliant attorney like Adam never gets a chance to go to bat because the person who's at bat is some guy who's like 90 years old. Hey, I'm still a professor at Georgia, and I'm not leaving my seat anytime soon until he dies. Okay, and so I would get rid of that. I'd put term limits on it all the time.
Okay, well, Nick, I can tell you that there was this old saying from the 60s that says, where you stand on the issues depends on where you sit at the table. Now, there was a time when I sat in young Adams' position, and I was for term limits as I was making my way up. But now that I'm long in the tooth and silver in the hair,
You froze up. I mean, the thing is, look, karma takes place here, Bill. Karma takes place here, Bill. You just got to get real. Okay, the thing is.
Okay, so in any event, that
froze up. So, Bill, are you for term limits or against it?
Okay.
You're freezing up. So tell us.
Okay, quickly. I'm against term limits only because I think that they inject uncertainty. I would be for a mandatory age of retirement.
Yeah, well, yeah, okay. Mandatory age of retirement. Okay, I would go for that because, come on, airline pilots have to retire at age 65. Okay,
Right.
because they just can't fly the bloody airplane, and that's about the time we're looking to hire our president. Oh, nope, a lot older than that, right, buddy? Okay, so the thing is, what we're doing is we're getting a seniorization of the world, and it doesn't give young people an opportunity to go anywhere. And it happens on television too, Bill. Just remember that. The senior people occupy the television positions. No one else is allowed on television until they die. I mean, this is ridiculous. And it happens in education over at where he's at. I've seen it. You know, those people, they'll sit on their professorships until they die. They're dinosaurs. They should have been removed a long time ago, but they won't. They're tenured professors.
Nick, I can tell you one reason it will never work. May I just in 30 seconds?
Wait. I have a book by the guy who founded Netflix that says it'll never work. So you can go on.
Okay, it's real simple because if nothing else, we've learned from this entire exercise, and we're going to get back to the upper end dialogue from the gilded class of LLMs, but this was a naked power grab by the conservatives to tilt the court left. And as long as there are naked power moves to influence coming from, and this is where I, as an ethical disclaimer, I come from the world of politics, and so I see absolutely nothing wrong with the various maneuvers. He or she who has the votes shall rule the day. But this is a naked power grab, and in the future there's going to be more. And I'm waiting for the day when non-originalists carry the day. But don't mind me, right? See, there you go, Chi-Chi. Now. Jeff, we've not heard from you. Do you believe in some sort of limits on the term or the time that a justice can serve?
Just a minute.
And that Adam talked about not expanding the court. I think it would, having the vacancies come up more often would further politicize the court. I am open to the idea of a mandatory retirement age for all the reasons that Nick talked about. So if somebody comes on the court when he or she is 50, and has to retire when they're 80, they get 30 years. That's quite a long time to make an impact on the court and on the direction the law takes. I think there would still be stability, and that seems to be the ballpark of where the appointments are coming now. They're around 50 years old. 48 to 55, I think, have been the last few.
Mm-hmm.
Okay, well, if I could pivot for a moment, because I want to ask, this is a bit a curveball to you, Adam, as a former pitcher. You were able to throw a curveball during your collegiate days, right?
I had a great curveball and a great changeup to make up for my mediocre fastball.
Okay. All right. Well, I guess my question is, and it was raised by someone in our audience, and that is, with a change in the court to generally more conservative, at least on social issues, with the addition of Judge Barrett, how do you think that is going to influence the rulings by the Supreme Court on gender issues? That is, lesbian, gay, transsexual, and bisexual community. Because it's a broad area. You can do religious liberty. We talked about cakes the other night, but I'm talking about more broadly in terms of discrimination, in terms of jobs, and that's got to apply, cause you to at least hesitate.
Well, I think that the first thing that the court is going to do is probably be a bit more careful about the cases where they grant cert. I think they're going to do their very best to avoid granting cert on cases that they know are going to be very divisive politically and socially. The second thing I think is that the court is going to be more originalist, and they're going to be more textualist. So they're going to interpret statutes based on the intent of the legislature and the words on the paper. I think they are going to reject any type of living constitutionalism or any type of interpretation, such as you saw in Griswold and Roe and even in Obergefell, where the Supreme Court essentially made up, invented unenumerated rights from the 14th Amendment based on a theory that made no sense whatsoever, substantive due process, and that essentially gave them unfettered power to decide what rights should and should not be recognized. So I think that's where you will see the court. The court's going to shy away from that because
Just a brief follow-up. Let me ask you. You raised earlier that that you believed one of the flaws was that it was based on the Fourth Amendment. Then let's just go to the Ninth Amendment. What rights can you see them using the Ninth Amendment to create new freedoms or new rights? And go ahead. I'm sorry.
No, I'm sorry. I could potentially see them creating rights under the Ninth Amendment if they could develop a workable standard that would allow them to confine the nature and extent to which they have the authority to create those rights. And I would go back to Washington versus Glucksberg in 1997, when Justice Rehnquist wrote the majority opinion saying, the court should be circumspect when creating unenumerated rights that can't be gleaned from the text, because that kind of undermines the democratic process and the idea that laws should be made from the bottom up, not the top down, and through decentralization, not centralization. So sure, you could recognize rights under the Ninth Amendment, but I would think it would have to be somewhat restricted to, does this right have any basis in the history and tradition of the country? Is it essential to recognizing, to effectuating individual liberty? But there would have to be some constraints on that so that it just doesn't give the court license to do what it's done under substantive due process.
Okay, Jeff, you're up.
All right. So my originalist argument on the Ninth Amendment is this. The Ninth Amendment, I don't know if I can quote it verbatim, but it says that the enumeration of certain rights under the Constitution shall not be used to deny or disparage other rights retained by the people. Now, as I understand that, that's a corollary amendment to the 10th Amendment. The 10th Amendment says that those powers not specifically granted to the federal government are reserved to the states or the people. And my understanding of this is that rights and powers are two ends of the same spectrum. And if you read Alexander Hamilton in the Federalist Papers, he's concerned about, hey, if we enumerate certain rights, then people are going to come along in later generations and think that that's all the freedom they have. That's all the freedom that's guaranteed. And he says there's a whole bunch of freedoms given by the fact that the government just hasn't been given any power to regulate in certain areas. They're sort of a negative rights idea. And he uses the example, why should we grant a liberty of the press, or why should we enumerate a liberty of the press? Why should we grant a liberty or say that it must not be done what there is no power to do? And he's saying, well, there's nothing in the Constitution that says that the government can regulate the press. So why should we create an amendment saying that? It might actually be taken to mean that the government can do anything it wants if it's not prohibited by the Bill of Rights. So I think all the Ninth Amendment is really saying is that the government has to stick to its enumerated powers, and there are certain freedoms that exist with the fact that the government is only granted specific and enumerated powers. I think the idea that we would start enumerating more rights out of the Ninth Amendment kind of turns that on its head. By the way, if anybody wants to read more about this, there's a great 200-page law review article out there by Thomas McAfee where he explains this whole argument on almost excruciating detail. But that's my view of it. I don't want to use the Ninth Amendment to start enumerating rights. I think the Ninth Amendment says that there are freedoms that exist by virtue of the fact that the government hasn't been given power to regulate certain things. And so they exist in the void. What's the analogy? We believe in islands of government power in a sea of liberty rather than islands of liberty in a sea of government power. So that's the idea. The Ninth Amendment, I think, is we have islands of government power in a sea of liberty.
Oh, Bill, you muted yourself. You got to unmute yourself.
Dietrich, for the sake of fairness, we've got two originalists who have been arguing, and we've got to give equal time to our side. Would you like to take the lead and make the argument that the Constitution is, in fact, a living document, and that what they're talking about is just intellectual gymnastics, rather than getting to the point that the Constitution has to live with us and it's for us as we move boldly into the future?
Oh, absolutely. Absolutely. I like that intellectual gymnastics that we just heard. But it's true. Supreme Court is different. Justices are different. Constitution is different. Think about it. Before recently, judges were invisible. It was a requirement for judges not to appear, not to be a figure. Like right now, we had a lot of rock stars and heroes that were assimilated into our society and made to stand for what we believe what, and actually were exposed and demanded to stand what we expected them to stand. And even though I agreed with a lot of causes that were exposed or prevented by certain figures, the idea of it actually troubled me, because Supreme Courts and justices should really be invisible. We are talking about the law, we are talking about the facts, we are talking about the issues. And that's a small indicator of also the Constitution itself. My core belief is that Constitution was drafted to last for a certain limited period of time. It was supposed to be amended because everything living is supposed to be different. And if we interpret like different amendments as they were written verbatim, a lot of factors that were included and named and written in the same Constitution are obsolete right now. So how we should interpret, so for this reason, also we have to pay attention to the public demand, to our expectations, to our interpretations, to what the society wants itself. Because right now, recently, people have been more vocal about the issues they care about, and they were taking it to the streets, and they were demanding to be heard. And justices should not only read what has been written previously or how it was interpreted, but actually to incorporate into the fabric of our society. And I think the society right now is different. So therefore, how can you have a different society, different justices, and the same governing body? It just doesn't make sense.
Okay. You actually raise a very, very interesting point. And Nick, you're nope. I just need you to pay attention. Just making sure you're alive there.
I got to wake up like I had to do in law class.
I saw you and drooling, and I can't have that because you're occupying.
Okay, I'm occupying space and time. I understand.
That's right. No, listen, your argument that the Constitution was not meant to live in its current form indefinitely raises the idea of a constitutional convention. And that happens to be an argument that has been advanced by David M. Walker, who we will be having as a guest on IBM TV, a featured guest on Monday, in his new book called America 2020, Are We Still a Superpower? But he calls for a reevaluation of the Constitution and a change, because it's it's within the Constitution that we have the right to change it. And I guess I'm going to ask this. Adam, with you and your proposals to change things, and Nick's notion of merit of an equity program, and Jeff's vociferous opposition to anything that might affect the red, white, and blue, or the stripes of the American flag, shouldn't we all just hit a reboot and get together and redo and take another look at our Constitution under a format that doesn't require never-do-well politicians and hacks like me to get our fingers involved in the mess, and rather let the American people once again pass judgment, so that we might be able to codify and therefore not necessarily need the penumbras, but with both Adam and Jeff hate, and yet I and Gayatri love, and Nick has yet to pass judgment on. So, a constitutional convention. Panelists, who would like to go first?
Well, I think that I would make 2 points. Number one, I agree with Jeff. I don't think the court should be creating unenumerated rights. In the event that it does, however, I think it should be rooted in the text, where at least you could say the court's creation of this right was based on a reasonable interpretation of the text. But number two, having said that, I don't think the debate should be between living constitutionalism and originalism. as much as it should be about constitutional ambiguity and what the court should do when the Constitution is ambiguous. For example, the Eighth Amendment prohibits cruel and unusual punishments. A law in Louisiana authorized the imposition of the death penalty for child rape. I believe it was in the mid-90s. Okay. The Eighth Amendment does not resolve the question of whether Louisiana's statute is constitutional. So my point is, when the Constitution is ambiguous or susceptible to different interpretations, the court should never get involved. They should let it be resolved democratically. And it's the involvement in cases where the Constitution is ambiguous that have led to 5-4 decisions and have led to the perception like, why the heck are 5 justices, if it's a 5-4 decision, deciding law for the entire country when the Constitution really doesn't speak to it? I think that's the problem.
Jeff.
If there is widespread support for a constitutional convention, the Constitution itself envisions that. I don't see that out there. I would personally be against it for the reason that current political trends, Justice Ginsburg, who just passed away, said that if she was going to create a constitution for our country, she wouldn't prefer our constitution. She would prefer something like the Constitution of South Africa, which is much more socialistic, and I wouldn't favor that. And you never know if you start a constitutional convention process, what you're going to get. Leading minds like that might go in that direction. So I wouldn't favor it. I like our Constitution. I think it's given us a pretty stable Republican form of government for 250 years. We're certainly not perfect, and we've had to amend it. And I think most of the amendments have been improvements. But if we need to reform it, I would prefer to amend it and take care of the individual problems rather than throw the baby out with the bathwater.
Oh, we can't hear you, Bill.
Nick, your thoughts?
Oh, a constitutional convention? Is that what you're discussing?
Yeah.
Okay. Yeah. I got it. It's a complete waste of time, effort, energy, money, and every other possible things. Come on, let's get real, Bill. Unless you have nothing better to do with your life, no one wants a constitutional convention. Okay, we have roads that are deteriorating. We have bridges that are falling apart. We have an infrastructure that's built for the 19th century. We do not high-speed rail lines. We do not have internet broadband everywhere in the United States. People in Africa watch us. People in Malaysia watch us, but not here. We have a lot of problems. Look at coronavirus. We can't even solve that. Come on. And you want to do a constitutional convention? Are you out of your bloody mind? Nick, forget it. Waste of time. Move on, buddy.
I do, because, I can't really survive in the elite world of LLMs, 1, 2. And I can't
it gives lawyers employment. I understand. We have 1.6 million lawyers. It gives them something to do. They can do a constitutional convention and talk about all the rights and all that other stuff. But it is a waste of time.
I can't pick up a shovel. Fine. Okay. Kiki, do you think it's a waste of time?
No, I don't.
Nick, please.
I think we are ready for it. I think it needs to happen. I think it needs to be done smartly. It's not a conventional style. I think there should be a lot of different kind of steps to get to there. But I do think that we need to talk about it. We need to familiarize about it. As Adam mentioned correctly, I agree with him completely, 100%. I think that Supreme Court became too politicized, and it shouldn't be like that. And we're losing it. It's actually the institution that holds the most power in this country and in the world, really, if we look internationally. And therefore, I think we need to spend time on it, to study it, to really find the issues. And I agree, it's going to take a lot of time, and it's probably going to happen through multiple years. However, I think we're at the point where I think it could be done, and I think it actually needs to be done.
Okay, well then let me ask the panel. Sorry, Nick, go ahead.
I said, okay.
Okay. Oh, ye of so few words, Nick.
Yeah,
You know?
well, I mean, if she wants the there is a point you could improve the document. I mean, we could use artificial intelligence, bring in Alexa, Siri, Summit, and create a document that's better than the document that we're at. And eventually, we'll get there, Guidry. But I just don't think the American public is going to do that, where they're all dying of coronavirus. That's
And
what,
being so politically divided.
and politically divided on top
But
of
Nick,
that.
I
Yeah.
love your technology input, like looking at the 22nd century kind of there. Love it.
Yeah, I have my Alexa right here.
Oh my God. Okay, please stop.
I'm not
See,
surprised.
Nick, this is an example of doing too much. Okay. Nick would have us turn over our entire democracy to AI so that we could institute a dictatorship. So, that's really kind of
It's more efficient.
it would be more efficient. Okay. But let me ask this question, and then I'll go in reverse order around the panel. And so, Guitry, you'll be up first. But that is this: do you think that that one of the silver linings out of this process so far has been that we are actually going to raise these issues and have at least some sort of discussion about what kinds of reforms we ought to have, or if we should have, to the Supreme Court, what they might look like, and and either amendments from Adam, term limits, from Bill, and AI from Nick. Guitry?
Absolutely. Bill, I think you hit the bullseye. I agree with you. I think we need to talk about it. It's definitely getting more attention. Hopefully people are not going to lose the main issues while focusing on a little distractions when it comes to really being so divided. But I do think that, and my nature is I want to be an optimistic, and I really do think that we're getting somewhere.
Okay, now Jeff, I guess I was talking to a friend of mine today who happens to be from the other side of the aisle politically from me. And in my past life, I was a Democrat. Now I'm a journalist, which means absolutely nothing. But what he said, because I'm really not even that.
You got a raise, but go on.
Right. Nick lets me play one for the time being. So, but Jeff, my friend actually had a legitimate point, and he said that in his estimation, he thought that it was a legitimate deal that he would make, that if his party were to lose the Senate and the White House for a period of time in order to solidify a conservative Supreme Court for the next generation. Now, with that in mind, do you think that would it be a bargain for you, Jeff, to keep the Supreme Court in its current construct, but in exchange for having serious discussions about reforms to the Supreme Court? Jeff, is that a bargain you would make?
Well, I guess I've got a couple observations on that. One is, if Donald Trump gets this nominee through, but he loses the election, he'll be the most consequential one-term president in a century just on that alone. And another interesting thing I thought, and I don't know if this goes directly to your question, but the most interesting thing I thought about today's proceedings on the Barrett hearings was the discussion between the senators at the very end, where they were talking about various issues of concern that they had. Some were concerned about the nominee in this respect or that respect with regard to race or criminal justice reform. And they were kind of figuring out that they had a lot more in common than they thought. And they were saying, we raised some issues here where we can work together and make some change. And I think that's a very healthy thing. I think the best thing about the way these hearings have been conducted, honestly, and I give Dianne Feinstein and Lindsey Graham both credit for this, is it was done in a very civil way. Mm-hmm. Even though there were contentious political issues discussed and the environment is obviously highly charged, the members actually were very civil and professional to each other, unlike that presidential debate we saw between Trump and Biden, which was an absolute disaster in my opinion. Mm-hmm. But the senators were actually all very collegial, and you could see it. And in fact, at the end, Senator Feinstein and Senator Graham got up out of their chairs and hugged each other. And it reminds me, there was a time in America when politics didn't have to be nasty.
Right.
I mean, I remember Reagan and Tip O'Neill could fight it out all day in Congress and then go out for a pint in the evening, and they liked each other. And you saw. I mean, I remember hearing Orrin Hatch say at Ted Kennedy's funeral that Ted would get up there and castigate the Republicans and give this fire and brimstone speech in the Senate, and then he would walk over and grin at him and say, "How'd I do?" And he says, "How can you not love a guy like that?" And I remember when Jesse Jackson it was discovered that he had a child out of wedlock, and Jerry Falwell's on, and I thought, now Jerry Falwell's going to take this guy to pieces. And he says, "No, I called him and he's broken." And we prayed together on the phone. And, here's these two ministers from very opposite ends of the political spectrum, but it turns out they love each other. They're good friends. Their families took vacations together. I mean, Jerry Falwell and Jesse Jackson, you'd never imagine that.
Jeff, you're going to put me you're going to put me out of a job with all this kumbaya stuff. But I mean, I'm listening.
But I think that having two parties that are strongly principled, but the people can get along and be friends, is a very good thing and portends better things for the future. I hope the rest of us in our social media and stuff will follow suit. Where, I mean, Bill, I consider you a friend.
I do too.
We don't agree on everything, and we don't have to. So,
okay, Adam, the repository of various schools of thought from the East Coast to the West Coast, now living down south. Your thoughts, Jim?
My thought is that originalism solves so many problems, and the first problem it solves is it prevents non-elected judges from deciding issues upon which the Constitution is silent and ambiguous, and from creating fictional doctrines like substantive due process, and it puts power back into the legislatures and the people to decide the laws under which they're governed. And I think that's critical, particularly when the Constitution is silent and doesn't compel a particular result. You mentioned in the other show, I think yesterday or the day before, that, well, it sounds like I would be creating part-time judges. Well, I would rather have part-time judges and a limited Supreme Court than judges who are working overtime and inventing rights that have no logical basis in the Constitution. And I think that's the legitimacy and to a more democratic and credible rule of law.
Nick.
Well, I've listened to Adam now for many days. It's kind of a hard thing to do, but I did. And the thing is, I think we need to pass a new act, the Substantive Due Process Repeal Act of 2020, except we got one problem. It's not in the Constitution. So so it's going to be really weird to pass an act to repeal stuff that isn't even in the Constitution. But I would be so far behind you in doing that, Adam. I'm totally favored of having a Substantive Due Process Repeal Act and pushing it through Congress, and then they'll all look around and say, well, it's not in the Constitution anyway, so what are we doing here? But it's interesting.
Mm-hmm. Well, this comes to that portion of our evening together when I get to say thank you in the most humble way that I can. It really is true that gathering people of goodwill, good intentions, and thoughtful perspectives really does advance the ball from time to time. And I think this is one of those moments. And now I lose my authority to the firebrand that is my senior citizen friend, Nick Palavita. Nick.
Oh, I just want to thank everybody for watching the Lawyer's Den. We're at 7:59, so we're going to bid everybody goodbye. Thanks, Professor Adam Guitry and Jeff, for attending, and hopefully we'll be able to see most of our audience tomorrow, and especially our friends in Nigeria and around the world on Lawyer's Den. We will catch you tomorrow.